rise. The Court of Appeals, Division 1 is now in session.
Thank you very much. Please be seated. This is the time set for oral argument in American Tower Products versus CSK Auto, Inc. Let's begin with introductions of counsel for the appellant.
Good morning, Your Honors. David Goldstein with my co-counsel, Prague Nishi, Herbert Dodell, representing plaintiffs, appellants, cross appellees.
Welcome.
Good morning, Your Honor. Leon Silver and Andrew Jacob representing SPA.
Okay, thank you. I'm sorry I looked at the wrong direction, but normally we have the appellant on this side, but don't worry about it. I think we can adjust our gaze. Let me go through a few preliminaries. Let me advise counsel that we have reviewed the briefs closely, pertinent portions of the record. We have discussed the case. We're familiar with the issues and the facts that you have raised in your briefing on appeal. Each side has 20 minutes. The appellant may reserve time, forgive me, I have to go that way. The appellant may reserve time for rebuttal out of your 20 minutes. When you go to the lectern, if you would like to do so, you might let us know how much time you wish to reserve, and that way we'll make sure that we try not to ask you too many questions so that you will actually end up with your rebuttal time. We are recording these proceedings today, both audio and video. And so for any listeners who may join us in the middle of the session, if when you go to the lectern for each of your opening or your rebuttal and so forth, if you please could just restate your name, that would be quite helpful. So I think with those preliminaries out of the way, let's go ahead and begin.
Thank you, Your Honor. David Goldstein again for the plaintiffs, appellants, cross appellees. We would like to reserve 5 minutes at the end for rebuttal. Throughout my career, I've been accused of having a keen appreciation of the obvious, and it stood me in good stead. And I'm sure this court can keenly appreciate that if it reverses Judge Foster's denial of the motion for new trial, the other issues in this case concerning prevailing party, reasonableness of attorney's fees, non-taxable costs, and costs need not be reached. So I will start there. And before turning to the substance of the new trial issues, I do want to say that my co-counsel and I firmly believe in the jury system and support it. But that system depends upon the operation of a jury that is free from improper extraneous influence, that is free from improper communications. But there was an improper communication in this case. We have a clear external and improper influence on the jury's deliberations in the form of the bailiffs answering a question about how long deliberations typically last. That the bailiff made that communication in response to the question is uncontroverted. And Perez teaches us, Perez versus Chandler Regional Hospital, that the truth of that communication and the response has to be accepted as true. To say that 2 hours is plenty is more than just an administrative detail. This is a bailiff who was present through a good part of the trial, if not all of it. It's opinion that the evidence that was presented at trial didn't merit a deliberation of longer than 1 or 2 hours. It's an opinion that testimony from many, many witnesses didn't merit thinking about for more than 1 or 2 hours. It's opinion that 175 exhibits presented over 12 trial days did not merit more than 1 or 2 hours. It's opinion that the issues that were argued strenuously and capably by my colleague Mr. Silver and myself didn't merit more than 1 or 2 hours.
Counsel, let me ask you. Holly Thorne, the declarant, did not join the majority verdict, correct? She was not one of the 6 who signed.
That is true, Your Honor.
And so your, I guess, working assumption or presumption is that she wanted to rule for your client, but give your client more money.
Your Honor, we don't know, and that's the problem here. This is a case, like in Perez, where the ability to determine whether there was prejudice or not given the nature of the communication, is difficult.
And what I guess, and I understand that. And the case law, I think, fairly has struggled with that same issue, particularly juxtaposed with Rule 606, which really limits the proper inquiry. But do you construe the Thorne Declaration, paragraph 8 of that declaration, as affecting damages or liability or both as decided by the jury?
I think it affects both, Your Honor. And one of the things, if you look at the affidavits, you will see that there are 3 of the jury panel who wanted to continue with the deliberations. And at one point in time then, one of those went over and became part of the 6 who signed off on the verdict form for the plaintiff. We don't know how that happened. And Rule 606, I think, would prevent us from getting into necessarily
Right.
the thought process.
Right.
But the process of when certain things happened, I think, could be inquired into to try to determine whether there was prejudice. But we did not have that opportunity. There was no evidentiary hearing held, and I think at the very least the 2 declarations of the jurors and the 1 declaration of our investigator, which I don't think you can rely on to prove the truth of the matter.
Right.
We agree that's hearsay. But I think at the very least it was a basis for an evidentiary hearing.
What would that hearing reveal?
I think you could reveal the process of deliberation in terms of what happened, not necessarily the thought process, but what was the status of the jury? Was there a vote at the point in time before the bailiff made the comment? Did the vote change? Did it have any effect on persuading a juror who wanted to deliberate to decide to go over with the other jurors who were putting pressure to say, we don't need to deliberate?
How do you get to that last point consistent with 606?
In terms of it would not be going into the mental process, but just the expressions of where they were in the course of the deliberation.
And then would the trial court, if that hearing was directed, would the trial court then be asked to decide whether a more complete record supported presumed prejudice or actual prejudice or none? I struggle with the case law that we have in Arizona, which is limited in number, about that middle part, when a trial court consider facts to determine sort of actual prejudice as opposed to presumed prejudice in the jury deliberation context.
You know, in Perez, we did have an evidentiary hearing, and the court does not really speak of actual prejudice as occurring there. It talks about presumed prejudice based upon what occurred at the hearing.
Which included 3 statements, at least one of which was substantively wrong, correct? I mean, that's how the Supreme Court characterized it. At least.
Right. That is true.
And that's
That was the
not
statement
really
about
this,
the...
That's not this case.
Well, I think the statement of the bailiff saying that 1 or 2 hours should be plenty substituted her judgment as to the length of the deliberation. And the law is that it's the jury, unconstrained by extraneous influence, that determines what the length and quality of the deliberation should be.
Was that a mandate, though, that this should only take you 2 or 3 hours? Don't we have to look at the context? If the question was simply, how long does it typically take? Isn't the answer necessarily somewhat innocuous as well? Well, these typically take a few hours.
But that was not the answer that was given, Judge Cantini. The answer that was given was 1 or 2 hours should be plenty. The use of the term plenty indicates a judgment of how much is enough, how much is sufficient. And that goes beyond just saying what's typical. And in fact, there is no such thing as a typical deliberation.
Well, we all know that, but
But when that's the question, the answer, if I'm asking a question, if I'm asking how long do these typically take, it seems to me that that's the response that you give is in that context. And so I'm going to think that it's, okay, well, they typically, but that doesn't necessarily mean it could take more, it could take less.
We don't know what the impact of that statement was on the jury. And perhaps you could characterize the statement as having some ambiguity in it. I think your interpretation of it, Judge, is potentially correct. But I think that the interpretation that I'm offering to the court is equally correct or maybe even more correct in terms of the use of the word plenty. Plenty indicates sufficient, enough. And so, and it seems directed not necessarily to what is typical. She should have answered to what 1 or 2 hours is typical, but she substituted something else. She put in that word plenty, which indicates a judgment about what is enough, what is sufficient for this case.
I'd like to ask some questions about where this might go. Let's suppose that we agree with you that the Q&A between the bailiff and one, perhaps, we don't know how many people heard this, but some 1 or 2 jurors was improper. Okay. And let's also suppose that we do not agree that we should just order a new trial. We think the court needs to determine whether it can conduct at this point an evidentiary hearing. So it goes back to the trial court, and let's say we have an evidentiary hearing. What can the court inquire? And I want to limit this to this aspect of the affidavit, paragraph 8. Because I will tell you, in my view, based on the research, everything else in the other affidavits is inadmissible under Rule 606. So my question wants you to focus on that communication between the bailiff and the
Certainly,
jury.
Your Honor. First of all, I would venture to say that given the length of time between the trial and where we are now and the expected schedule for a remand if that occurs, means that there's been quite a bit of time, and getting everybody together, I think, is going to present some practical problems.
But let's assume it happens, okay?
But beyond that, first of all, we could find out when this statement was made. Was it made at the beginning? Was it made at the end? We could find out, did the jurors hear it? We could find out whether or not jurors who wanted to deliberate decided that they did not want to deliberate.
Doesn't that get, let's take it piece by piece, or step by step. Doesn't that get on the wrong side of 606B? I mean, for example, could you ask the juror, did you hear the bailiff's statement? Well, let's say the juror says yes. Then, question, could you ask the juror, what did you understand the bailiff to mean? Is that proper?
I think that's verging right on the line, Your Honor.
Okay, that's not. So then what could I ask?
So I think at that point in time you could say, did everyone hear it? Yes. And then you could say, was there any change in the vote? Because we know from Perez there was consideration of the fact that at some point in time in the deliberation the vote was 4-4 and then it changed. So the court in Perez did have that before it. So we could determine whether or not there was
So
a
you're
change.
saying you could ask, for example, did it occur before or after a vote?
Correct.
Yes or no? That's objective. You're not asking how they voted or what they thought when they voted. It's just you're asking objective information.
We could ask before the question and answer was given, was there a investigation review of exhibits? Was there any discussion about witness testimony? Without going into what the content of the discussion was, it's a yes or no question. And then we could say, after that happened, did the jury look at exhibits? Did the jury discuss witness testimony? Again, without going into the substance or content of what the discussion by the witnesses was. I think all of those things are within the ambit of what Rule 606 allows.
But are you suggesting, though, that if anything happened, presumably something happens after the question didn't come after the jurors have all voted, presumably, and then the bailiff says, this is all it should take, and then they say, okay, well, here's our answer. I'm assuming that it occurred sometime well before that. You're saying that it matters how far before that, or?
I think it matters when in the process, and we're only talking here about process. We're not necessarily talking about substance. So I think it matters when in the process and what effect did the colloquy have on the process.
The effect is what I'm particularly concerned about, given 606. And let's say, to follow up on Judge Norris and Judge Catani's questions, that the response is that something changed then. Yes, we talked a little bit about something later after this colloquy, and that more than 2 jurors heard it, which I think would be kind of a minimum requirement. What then? I mean, how does that show prejudice?
I just think it depends upon how it came out and if there was a change, and in terms of whether some jurors wanted to continue to deliberate and then they gave up and decided that they wanted to go home. Again, I think it goes to process. I think what may be instructive, because
let me interrupt you there just for a second. If some did want to and they gave up, does that by definition show prejudice?
It could, because...
And I understand it might, but at some point in time, unless all jurors are of one mind, and in civil cases where damages are disputed, that doesn't happen very often. At some point, there is you can call it a compromise, you can call it whatever, sort of in the ordinary course. And so when given this comment, how does that alter the formula? In other words, when's enough, or is it presumptive?
I think it's hard to. That's why we have a trial judge who exercises discretion, and I think it may be that in this case we have to rely upon the presumption. But if there is a remand, at least we may be able to strengthen that presumption by what the answers to the questions are. If I may, I only have a few seconds, but I would like to advert the court to the discussion in our answer brief and reply brief of the Caldwell federal case, where there was an evidentiary hearing. We dropped a long, I think that's Caldwell, where we dropped a long footnote about the type of hearing that was conducted to determine whether there was prejudice or not. And we actually had the court describe juror testimony where the juror said that she was not prejudiced by a particular statement. Now, the federal rule 606 that Caldwell was applying is, I think, either very similar or the same as our rule. And so I would just think that may help the court in terms of the struggle that we've all been going through here today about trying to figure out what would be permissible in a hearing on remand and what would not.
Can I ask you one more thing before you sit down? Can we look at it, when I look at the closing arguments, your closing seemed to focus, or I think it's the closing rebuttal, seemed to suggest, I think it was an invitation to the jurors, you don't need to look at a lot of documents. I want you to look at one document. It's on page 154 of the transcript, and it just says, I want you to look at one document. What you're going to see is that just look at exhibit number 412, tab 2. That's all I want you to look at. What you're going to see in tab 2 are all the times that the checks were paid. I mean, it seems to be a little bit of a focus on suggesting that this isn't necessarily overly complicated. If you look at this is what I want you to focus on as the jurors. So does that affect our analysis?
I think that particular comment by Mr. Dodell during closing was addressed to one of the claims, the prompt payment discount claim, and he was addressing the jury to that. I'm not sure that he necessarily meant it or it was intended to say that's the only exhibit that you should look at.
Let's do this, because this is a difficult issue. We want to make sure you have adequate time for reply. So I'm going to ask the bailiff to upward adjust and go back to 5 minutes for the appellant, and then could you give the appellee an additional 3 minutes? Okay.
Thank you, Your Honor.
Okay. Or maybe it's an additional 2, just even it out, okay?
And may it please the court, I'm also a cross appellant, and honestly, I think the cross appeal is far more important here. And I wanted to ask the court if I would be able to reserve time to rebut on the cross appeal issues that I plan on addressing. And I'd like to reserve 3 minutes for that.
Do you have any? I will tell you, I don't think we normally do that, but let's go ahead and do that since you've asked about it.
Thank you, Your Honor. And to address the court's concern, all of the things that Mr. Goldstein just said that the court could consider in a hearing, the court could have considered in their motion. They could have had their private investigator that they hired right after the case ask the juror, well, when in the process did this occur? Was there a vote? All of that stuff, they could have asked him and they could have submitted that, and I would suggest that that was their burden to do, because the trial court still has a gatekeeper function that is appropriate for the trial court to undertake in that situation. And that's to determine, because we didn't dispute that the comment was made, but that's to determine under an objective standard whether the comment that was made would be such that it's reasonable to believe that it would affect a hypothetical reasonable juror. Not what it did to these particular jurors, whether it would affect a hypothetical reasonable juror. And the trial court told us he saw this as a throwaway comment. He saw it as innocuous, just as the judge said, and it was an offhand answer. And more importantly, he said, having sat through all of this, he didn't find the length of time that they deliberated to be stunning at all.
Well, let's scroll back here and really look at this. I think it is a troublesome comment. I will tell you. First off, the question that was asked may not have been so bad or so problematic. The answer, she told us an hour or two should be plenty, Speaking in the present tense, should be plenty seems to be directed at this case. And it just strikes me that your argument, Mr. Silver, is based on an assumption of all sorts of ways these jurors would have understood that comment. And I don't know how they understood the comment. I don't know how many heard the comment. I don't know when in the course of the deliberations the comment came. There's a lot of things. I felt almost like we're into Donald Rumsfeld, the known unknowns. And, so I think we have to start from the presumption, objectively, that this comment was improper. Then the question turns to, well, what do we do about it now?
Well, there's another question. And the Dunn v. Maris case, this court said that once there's an improper comment, when juror affidavits demonstrate that extraneous prejudicial information was improperly brought to the jury's attention, and there is a reasonable possibility that the verdict was tainted, the trial court must order a new trial. So there's a second component, and that's what the trial judge is left in his discretion to determine, whether there's a reasonable possibility that the verdict was tainted.
Well, here's the problem. This trial judge did not hold an evidentiary hearing, and the appellants requested it, at least in the alternative. And so the trial judge was basically making his determination based on, as far as I can tell, no additional information other than this particular communication. The trial judge's assessment, I mean, I can make an assessment if I don't have facts, I can still make an assessment. It doesn't mean my assessment is valid, though, because I don't know any of the background.
The fact that could possibly be in dispute here, we did not dispute. The fact of the statement. If the trial judge made had an evidentiary hearing, it would have been to determine whether the statement was made. And that's what the other cases say, that hearing has to be limited to.
No, it goes beyond not just whether the statement was made, it goes beyond whether the statement could be deemed to be prejudicial.
So there's an evaluation of the statement itself. There's not an evaluation of the rest of what was going on in the jury room.
But case after case says you have to look at the context of the statement. You just can't say, here's a statement, I'm going to blind myself to all context and determine whether the statement is or is not potentially prejudicial.
I don't believe that the court blinded itself to the context. The court knew the context of the statement. The court sat through the trial. The court heard the closing arguments. The court knew what the question was and knew what the answer that was given. The court said the court wasn't stunned at all with the length of deliberation. So in the court's exercise of its discretion, it decided that from an objective standard, a reasonable juror in this case would not have been, their deliberation, their result would not have been affected by this statement at this time in this context.
Let me ask you an additional point here. In looking at the trial record, we noted that the jury had raised a question regarding the length of the trial. I believe it was during on 928, the 928 transcript, at least they had raised a jury question about, because there was a day off for a holiday or something, they were concerned that the trial might run past the original completion date. So it came up once. Then, and apparently, even though we don't have the voir dire, there was some type of assurance or statement made by the court as to when the case would likely go to the jury. So they're expressing concern whether the trial's going to run past the original completion date. That issue came up again a little bit later in the trial. So we have objectively in the record concerns expressed by the jury regarding, are they going to be able to get out of there before a 3-day weekend? And then we have this statement. I would have thought, looking at what happened at trial, given the jury's concern about how long this trial was going to last, plus the bailiff's communication, that perhaps would warrant an evidentiary hearing to understand precisely what was said. Was anything else said by the bailiff? Who heard it? When was it said? I mean, all the objective points that Mr. Goldstein identified.
Well, because the standard is an objective standard, Mr. Goldstein had the obligation to come forward with that evidence to put in front of the judge, to ask the judge to make his determination, because we weren't disputing.
You don't think what he put forward was enough to have the judge get to an evidentiary hearing?
Not once we agreed to it. If we disputed that it was said, then yes.
You don't have the surrounding context.
But that's not what the standard is. The standard is, if extraneous information is brought to the jury, then the judge has to evaluate it on an objective basis. Not on here's what exactly happened in the jury room. It's whether the statement rose to a level that would lead a reasonable juror to change their mind or behave differently in the deliberation. And Rule 606 keeps us out of the rest of that discussion. So this does not rise to the kinds of cases where there's been a new trial, or there's where the court has done something about this, are so much. So there's such a greater deal of prejudice that we're talking about. In Dunn v. Maris, one of the jurors.
Before you get there, let me follow up on a couple of questions Judge Norris had. You are effectively saying, do I understand it correctly, that no matter when this was said, no matter how it was interpreted, no matter what, it doesn't constitute prejudice? There's not a laboratory circumstance where these statements could constitute prejudice. Is that your argument?
No, that's not my argument. My argument.
Help me understand.
No, my argument is that under an objective analysis, this doesn't rise to the level of the types of situations that the court would find prejudice, but we're not looking at this in a vacuum.
It could not have risen, right? I mean, objectively, never.
Correct. Objectively, this statement in this context, given the rest of the affidavit as well, and I say that with just for one point to the judge's question, the affidavit does appear to be chronological. And so if you read it that way, the statement's at the end. But that's the only other fact you have.
But assuming, doesn't your argument require us to assume it was said at the most critical time for deliberation?
Yes.
Okay.
Yes.
And were closing instructions, did they deal with timing or scheduling for deliberation or not? They didn't seem to, from my read.
I don't recall. I am very sure that we would have used the Raji on
right.
the giving the case to the jury. I don't recall either of us proposing anything beyond the Raji, and I could not, for the life of me, recite the Raji to you right now.
No, believe me, nor can I. But one of the reasons is the instructions as given, at least the filing as opposed to the transcript, appear more. It's less pristine that we have the exact copy of what was provided to the jury on the record. But it didn't seem to me that jury deliberation scheduling was addressed.
No, and there was no discussion about certainly there was no discussion about how long it should take by the judge.
Yeah. No, I think there's no dispute about it.
We know that.
I do want to address the successful party issue. I understand the court's, that's a real meaty, substantive issue that we're talking about with the jury irregularity. I think the trial judge did what it was supposed to do in the exercise of its discretion and handled it. The successful party issue, though, this is a real interesting hypothetical. I'd almost like to use it in a class to teach lawyers. Imagine a client walks into a lawyer's office and says, I've got this great case against this company. They owe me $10,733. And the lawyer says, okay, I'm going to charge you $2 million or even $750,000, and I'm going to get you that money. This court, the bar, the rules of professional conduct would certainly frown on that discussion.
I think Judge Corcoran, or Justice Corcoran, when he was on this court, wrote a decision in which he had that situation and talked about this was where the case was about the dog's tail or something to that extent. So I think those cases have come up. And
in this case, to be more like this, I mean, that hypothetical matches essentially the result of the trial court. In this case, it would be more like the client went in and said, look, I think I have some claims against this corporate defendant with a lot of money who's been in a lot of trouble and has some indicted officers. And the lawyer said, okay, well, we're going to come up with $10, $11 million worth of claims to get them, and the jury's going to hate them, and we're going to get you a bunch of money. And you got them $10,733. I mean, common sense tells you no one believes that plaintiff would be happy with that result, particularly after spending $2 million in attorney's fees and only getting a third of that back.
Although, let me ask you, we've talked about discretion, and a trial court has substantial discretion to determine who the successful party is. Isn't that correct?
But the trial court doesn't have discretion to misapply the law. That is always an abuse of discretion.
Fair.
And
or sometimes called an error.
An error of law, certainly. The trial court does not have the ability to say, okay, I have the discretion to decide this, so I'm going to ignore the law and just come up with this result over here, which, from everything he wrote, appears to be what the trial court did. Now, he mentioned the appropriate test, totality of the circumstances, with some recognition of the percentage of success, but then completely ignored it and wrote in his opinion twice that he was going to determine the totality of circumstances based on a net judgment and the percentage of success based on a net judgment. APP got something, CSK got nothing. Therefore, APP wins. Well, that's not the law. I mean, this was a more complicated case than that. Although,
forgive me. It's now complicated for purposes of attorney's fees, but not so complicated for purposes of the jury issue.
I said it was a more complicated case than that, but I didn't say I didn't go that far.
That's true. You didn't.
And I mean, Your Honor, I mean I have this blow up here, which takes some information out of our briefs that we've laid out to show the court how this case really worked, and I don't know if you can really see that. Let me. I know they know what it says. They've seen all this before. Basically, CSK claimed throughout the case that there was an open account. That was our counterclaim. The main part of our counterclaim was there was an open account balance that was in our favor of $102,000. And that open account balance was based on one of the tabs in Exhibit 412. It was the check detail tab. It's a 32-page spreadsheet with thousands and thousands of items on it. This is a statement of the closed items of the account, the items that were already paid with discounts applied. I'm sorry, I misspoke. The $102,000 balance was the balance of the open items of the account. So the same trial, Exhibit 412, the excerpt of the record 386, on the open AP tab, there are a number of invoices totaling about $780,000, and then there are 49 credits against that invoice. And it's a two-page spreadsheet with all those items on it. The balance of that spreadsheet after application of all the credits, all 49 credits, is $102,000. The plaintiff's claim was that in the closed items, CSK improperly took discounts and return charges and return freight, and that was based on our statement of the account, which is the same exhibit, but it's a different tab, the check detail tab, which is the 32-page spreadsheet. We agreed with them that there was one item on page 32 of the spreadsheet, 5 items from the bottom, for $113,310 that we said, you're right, we shouldn't have taken that. So when you credit the $113,000 back, that's how you get $10,733. So we said, as a result of all of these, thousands of transactions, 33-page spreadsheet, open account balance, when you net it all out, if you agree with all of the charges that CSK has applied to this account and all of the credits that CSK has taken, we owe you $10,733. That was the result of the stipulation, too. From there, the plaintiffs claimed, yes, but in this spreadsheet and in this spreadsheet of the closed items, you took $6,297,000 worth of credits that you weren't entitled to for returns, for freight, for improper prompt payment discounts. You add it all up, you owe us $6,297,000 for that, and you owe us $4,540,000 because since you didn't pay us for those items, it cost us other business. So they wanted $10 million, almost $11 million. So CSK litigated for 7 years over these hundreds and hundreds of disputed items. These main, even as the trial judge recognized, the main claims in the litigation regarded the claim of improper returns and the claim of improper discounts. And at the end of the day, the jury said, you're right, CSK, we agree with you. You didn't take any improper discounts. You didn't make any improper returns. We don't believe anything they say. We're agreeing with you on every dollar. If they'd agreed with APP on a single item, on a $1 discount that was wrong, they'd have awarded them $10,734. But they didn't. They didn't agree with them on anything. So I stood in front of the jury and I said, if you agree with us on what the balance of the account is and you don't want to award us the other counterclaims that we raised, enter the verdict form this way, for plaintiffs for $10,733. Clearly they did what I asked them to do. That was what we wanted them to do. We've all been in trial before. We know how this works. For the judge to look at that and just completely ignore and to make the statement that CSK was not successful on a single claim other than one of the parts of the stipulation was just factually wrong. And for the court, so even if the court did examine the totality of the circumstances, he did so in a way that was an abuse of discretion. He completely missed it. We won this case. We won millions of dollars of claims. We got what we wanted. We got what we claimed the balance was. And
now, counsel, you say that because the numbers in the plaintiff's verdict were smaller than they sought. Is that fair?
I say that because the number in the plaintiff's verdict was exactly the number that we had suggested it should be.
Fair enough, but that in suggesting that, I'm thinking as an alternative. In other words, you would have been happy with zero, or something even heading your way. But you are effectively conceding liability and saying, but the number should be comparatively very small.
Not entirely, because
Okay.
this is an account case. I've done dozens and dozens and dozens of account cases in my career, and it's one of the hard hurdles to get people to understand. An account case doesn't have a clean zero part. There's a balance due. The balance could go one way or the other, and each side has a different version of the account
Understand.
as to where it goes. So I mean, we've had account cases where, we claim we owed the other side $300,000 and they claim we owed them $9 million, and the judge says $300,000. Well, we're successful in that because that's what we claimed we owed them. So but that's why it's so hard to do a bright line net judgment.
And that's fair, but I want to understand your argument because it's something different than plaintiff awarded the number or the jury awarded plaintiff the number we suggested. Because if that was being a successful party on the defense side, every time you got to that in closing, you'd never have a plaintiff being a successul party potentially.
I understand what you're saying, and yes, I agree with that because this wasn't just we put out a number for the jury to take. It's not like, okay, they want $4 million for punitive damages, and we're saying, well, no, just give them $1 million. There's a reason for our number, and it's directly related to the claim that we were trying to prove from the beginning, and it's directly related to all of the evidence that's in the case and all of the discovery that was done. There's a specific number that we believed was right. And because we recognized the risks, we offered significantly more than that, and significantly more than the plaintiffs ever were going to see as a result of this case in our settlement offers and in our offer of judgment. And we have that whole separate issue on the offer of judgment itself. The court still hasn't explained how it got to where the court has no discretion under the rule. It didn't award us sanctions under the rule, and it never explained its math. But there's under the totality of the litigation, there's a whole list of factors that this court just didn't even look at, and including the settlement offers that were made, including the lack of success on claims and the success on claims of CSK. I mean, the court just factually misstated that. I've run out of time here, and obviously could talk for hours and hours more about this. So
go ahead and sum up. That's fine.
Well, yeah, I mean, Your Honor, I think this all comes back to common sense and what we want the trial court to be doing. I mean, the trial court judge, is there in the courtroom and observing what's going on, and has discretion in some things and doesn't have discretion in other things. In terms of applying the law to the case to determine under the proper test who the successful party is, the court doesn't have discretion to ignore the law on that. And at the end of the day, we want the court to use its discretion to come to something that makes sense, makes common sense. So when you're looking at what went on in the jury room and the statement made by the bailiff to the juror, the court has to take that initial bite at that and has in its discretion to objectively evaluate that statement, and this court should honor that unless he abused his discretion. When the court, in determining who the prevailing party is, comes up with a result that's so beyond common sense and misapplied the law that was supposed to be applied to that, this court has the obligation to correct that.
Thank you.
David Goldstein again for the appellants, cross appellees. First, as to the jury issue, Mr. Silver said we had a burden of having our private investigator go beyond what she did. We're facing a very delicate balance here. We don't want to be involved in jury tampering. We don't want to be involved in hassling a juror. We don't want to be involved in creating pressure on a juror. What we had was enough to present a real serious issue to the trial court. And the trial court had a three-part decision tree here. You could say it doesn't mean anything, which I think this court is troubled enough to say it does. It is enough to really think about. Number two, the court said...
So what triggers the need for an evidentiary hearing? If I'm a trial judge and there's an affidavit that suggests that these are the facts and the other side doesn't dispute that those are the facts, why do I need an evidentiary hearing?
Well, I think it would be within the judge's discretion, properly exercised, to say, I don't need an evidentiary hearing, we have a new trial here. It could.
Do you agree that it's an objective standard?
I think there is some language in the case law that talks about it being an objective standard, but the question then is, has the judge abused his discretion in applying that objective standard? But we also have a situation where Perez tells us that it has to be established on a case-by-case basis, which means the objective standard is colored by the facts and sequence of events in the case at hand. So here, in this case, what the bailiff did, again, we think justified a new trial without an evidentiary hearing, but at the very least there needed to be an evidentiary hearing. In terms of the successful party argument that Mr. Silver brought, there's one element that's not on that chart, and that element is the counterclaim for $1.6 million that they have tried to minimize consistently in their briefs as simply being defensive. But when my client got a demand letter, the demand for payment for the post-termination returns was included in that demand letter. I believe is an exhibit, although I don't have the exhibit number at hand. And so this would be a situation where the client walks into the lawyer's office and says, I have a $10,733 claim against these folks, but they're going to bring a claim against me for something a little less than $1 million. And so was what we did to defeat that claim as well justified? The case law on successful party says that it is a discretionary decision with the judge, and if the judge selects a mechanism for determining who the successful party is, that's not going to be disturbed unless it's an abuse of discretion. And the net winner standard is a standard that has been accepted by the Traub versus Kerner in connection with costs, by Ocean West versus Halleck in connection with fees. In this case, that was an appropriate standard. I have not found any case where an award of attorney's fees based upon a contract provision as opposed to Arizona Revised Section 12-341.01, where the only claims were monetary, where the net winner standard was not applied. In Murphy versus Farrell, by way of example, this court recognized that there are occasions where there is a contract provision where the net winner standard doesn't apply, which gives a negative implication that there are cases where it should apply and does apply, and this is one of them. In Murphy-Farrell, in contrast to this case, in a distinction that Judge Foster recognized in his under advisement ruling, the net winner analysis was not applicable. Why? Because nobody had any monetary claims. Now, I recognize that Ocean West talks about the fact that who won monetarily is not always a factor. Let's take a hypothetical. There's a plaintiff and a defendant. There's a contract case. There's two contracts. The plaintiff has a claim on one completed contract whose term is over for damages. But there's an existing contract, and he brings a second claim for declaratory relief because he wants to know an interpretation of the contract, how there should be certain kinds of performance, whether there's certain duties that he has or whether there's certain duties that the defendant has. And much of the trial goes with that declaratory judgment. And on balance, it's a much more important decision for the trial court. In that case, maybe that language of Ocean West might apply. But that language, in terms of what the decision of Ocean West was dicta. And the fact that they accepted Mr. Silver's suggestion is another indication that what the bailiff said had an impact.
Well, thank you both very much. We appreciate your arguments and your briefing in this matter. We're going to take the matter under advisement and issue a decision in due course. We run a little bit over time. We'd like to apologize to the next group, the litigants in the next case. We're going to take a very brief recess so the board can reset up the courtroom, and we will stand at recess. Thank you very much.